Ready to take your verdicts and jury selection to the next level? Jury consultant Harry Plotkin and trial lawyer Dan Kramer are your ticket to tipping the scales before trial begins. You're not just picking a jury, you're picking justice. Produced and powered by LawPods.
All right, welcome to another episode of Picking Justice. I'm really excited for this one. We're leaving sunny Southern California, Harry, and headed to the Northeast, which I hope is also nice and sunny today. But I am very excited because we have two firsts, Harry. We have our first AAJ president who is gracing us. We now have, plaintiff bar royalty here on this podcast. We also have the first guest who is literally in the middle of picking a jury, like left picking a jury today, and we'll go back shortly to pick a jury. That's a Picking Justice first. So with that, we have the amazing Kathleen Nastri here, who is really just one of the top trial lawyers in the Northeast, if not throughout the country, has had amazing verdicts, mostly practicing med mal, $58 million verdict, which was the largest medical malpractice verdict in Connecticut history. $12 million verdict, I can go on, but she is a leader in the plaintiff's bar, not only in the country, but Connecticut Trial Lawyers Association. So Kathleen, how you doing? Welcome
Great.
to this podcast. We're really excited to have you.
I'm hoping to pick up some tips from you guys, so when I go back, I get the right jury.
Yeah, exactly. You get some free jury consultant advice here from Harry Plotkin,
Right.
all the way from Pasadena, wherever you live, somewhere over there, Harry.
Close enough.
Yeah, close enough. All right, so let's jump into it. So we were talking a little bit before we came on about how in the great state of Connecticut, you guys do things a little different than the rest of the country. Is that right?
That's right. Well, in many ways, but I think you guys want to hear about
Yeah.
about jury selection. So we, as far as I know, we're the only state that does what we call individual sequestered voir dire. It's guaranteed in our state constitution, which is, really amazing if you think about it. And so when we pick a jury, we see each individual person by themselves, alone in a room, one at a time, and we can spend hours, with each individual juror and weeks trying to get a jury that is the right jury for the case. So it's good and bad.
So what I picture, our common friend Dan Algalani, he's told me about this years ago, and I just picture that scene from Office Space where they have to go meet the Michaels, and like someone has to like walk in and sit across like a job interview, and like, is that how it is? Like the juror just comes in, two people are sitting like one side of the desk, and then
So it depends.
crazy.
So sometimes we actually do it in a courtroom, but like today what I'm doing, I'm in Bridgeport, and the jurors who are waiting to be picked are sitting in the courtroom in the jury box. And then we're sitting in the actual jury deliberation room, which is just as you would picture it. It's a table with a bunch of chairs around it. And we go out to the courtroom. We tell the juror we're ready to speak to them. They come in, sit at the end of the table. And then we, one of us asks questions until we're done. And then the other one asks questions until they are done. And then we make a decision right there.
It's kind of similar. Pennsylvania does something a little bit similar. It doesn't, I think there are time limits. The way it works in Pennsylvania and a lot of counties is the jurors come in, there's a list of questions that both sides have submitted. The clerk asks them one by one, has anyone here ever, operated a business? And the jurors raise their little paddles with their numbers, and everyone writes down, okay, number 2, number 7, number 8, and you go through all the questions, and then you start taking them back one by one. Usually the judge is in the room. It's kind of a little different, a little weird, but then both sides are allowed to follow up on, okay, juror number 1, you said yes to this and this and this and this and this. You can't really ask new questions, but you do get one-on-one. And so, yeah, I don't know if you've ever done one in Pennsylvania, but it's a little similar, but it doesn't take weeks. It takes a couple of days only. You got to go quick.
I have not. The other thing that we have a very brief introduction in the main courtroom. So the jurors know it's a malpractice case. They know who the parties are. They know a very little bit about the case. This case involves a prostatectomy that went bad. And so they know that. So when they come in the room, they might immediately want to tell you something about what they heard. But for the most part, they come in knowing nothing. And we know very little about them. We don't have Wi-Fi in our courthouses, so we struggle with the whole Google looking up information about people. We don't have the lists the day in advance or 2 days in advance. We get a list a minute before we get the juror, and we have their name, and it tells us where they live and whether they've had jury duty before, and that's about it.
Just maybe this is too much of a history lesson, but what is the philosophy behind this? Like, what was the theory I guess when the legislatures were putting this together, why do it this way as opposed to the way most of the country does it?
I am not really sure, Dan, but I think, Connecticut's nickname is the Constitution State, and we take our Constitution very seriously. And so I think the right to trial by jury was so embedded in the people who wrote the Connecticut State Constitution's minds that they were very mindful that nothing should interfere with not only the right to trial by jury, but the right to a trial with a fair jury. And so we have never changed it.
Yeah, I got to imagine. I mean, you probably do sit very fair juries because you have so much time. No, I don't know. I mean, maybe
No,
not. I wonder if
uh,
it works.
I think at the end of the day, honestly, we have the same issues that people have around the country. So
Yeah.
people don't always tell the truth when they're in jury duty. Some people have an agenda that they don't want you to know about, and it's easy for them to hide that, whether they're sitting in a box. Sometimes they're sitting across the table from us. I'm not a trained psychologist. Sorry guys, but I don't usually use jury consultants. And I probably should, because I often get snookered by people that I think we're going to be great jurors that aren't. So I think, to some extent, we should be able to root out the people who are going to be terrible for us, but it doesn't always work.
So they come in, and then what's your philosophy on kind of how you talk to them? Do you have a set of questions? I mean, if you can spend like all the time in the world, are you asking the same questions to each juror? What's your kind of overall philosophy?
Yeah, I'm very big on not having an outline, not having questions written out. And I ask a lot of just open-ended, how do you feel about questions? Because I think you can tell a lot by how they'll answer. I just was sitting with one of my young associates who was doing the questioning in this case, and it was a lot of, do you agree that doctors should be held responsible if they do something wrong? Do you agree that you could fairly compensate? Yes, yes, yes. I just say, how do you feel about people who sue doctors? How do you feel about lawsuits? That kind of stuff. And then you will get something from that person that you can either follow up on or will tell you that there's something hidden beneath the surface. So I sort of have a conversation with people, and I'm very good at asking people questions without making them feel like they're being cross-examined. So
I think my biggest question is, a lot of lawyers out here in California, you're doing the voir dire in front of at least 12 jurors at a time, if not 18 is probably the most common. We call it a 6-pack here. Some judges have you do the whole room, 40 jurors, 50 jurors at the same time. And so a lot of lawyers out here really rely on the fact that the whole group, and if you just get one juror expressing a bias, it makes it so much easier to break the ice. And now who else feels that way? You can't do that here. You're one-on-one. You can't go, you remember what juror number 2 said? And they're like, no, I wasn't in the room when juror number 2 said that 2 days ago. You have to do it from scratch every single time, right? And so you have to break the ice 40, 50 more, maybe more times, right? How do you do that each and every time? How do you get them warmed up and feeling comfortable in expressing potential bias?
yeah, I mean, it is kind of exhausting, right? So if you start out like you would start any conversation with a person in a coffee shop, you get them talking a little bit about themselves and a little bit about their background and a little bit about what they like and don't like and what their hobbies are and their kids. And, suddenly you have a little bit of insight into the person, and they just start talking. And I mean, we just sat with this woman, the first person we questioned today, who was an African immigrant, and we learned an incredible amount of information. In fact, I took about 18 pages of notes on her. I think there's nothing about her that I don't know at this point. And my only question when I left the room was whether she would be good on the non-economic damages, because she was very hesitant on that. But by the end of this conversation, she was so comfortable with us that we learned that she went through a difficult divorce and she had to leave her child behind for 4 months. And so there was like this they suddenly feel like they're just talking to their neighbors, which is how it should be.
How did you get her to those personal details? I mean, what led you there? What led her to open up and just share all that?
So I think there was a question to her, because she's an immigrant. So there were a lot of questions about, how long have you been here, and how did you get here, and why did you come, and what brought you here, and her educational background. And she's an extremely, like, a highly, highly educated woman who is working in a job that undervalues the education that she has. But the question was, have you ever had any contact with the legal system, good or bad? And she said, well, not here. And then she talked about this experience she had in Kenya. And I think it's really important to exhibit zero judgment when people tell you things.
Yeah.
Yes, I'm biased about this. Yes, this is my job. I watch Fox News, whatever it is. I just nod my head and keep asking them questions. So she was just very comfortable. They're not always that comfortable. I mean, I've had people refuse to answer questions. I've had people tell me that the question is too personal. We always tell them in the beginning.
They want a sidebar
I was
within a room of 3 people.
Yeah.
Yeah.
Usually it's hey, we can go aside with the court reporter, the judge, and everyone else, and we'll make it real private. Like you guys are already.
Yeah.
I mean, you're basically a confessional, as
Yep.
is.
But it sounds like one way that you approach it is that you don't just jump in and pounce on, cross-examine them. And can you be fair? Do you have a bias? You get them talking first.
Right.
No right or wrong answers. And so by the time you kind of come to asking them about potential biases, they feel comfortable talking to you and they don't feel like they're being, which is huge because I see a lot of lawyers just jump on top of jurors too quickly and just try to pin them down on bias within the first couple of minutes of talking to them.
Yeah. No, there's very much a little dance, before we jump into the questions. And the bias stuff, I always think it's kind of easy because you can say everyone has biases. Everyone has prejudices. We don't always recognize them, but we do. And we're just trying to find out if you're the right person for this kind of case. For example, this were a criminal case, which it's not, and you had been the victim of a burglary. And this was a case about a burglary. For all really obvious and good reasons, you might not be the right person for this. So we're just going to try to find out if there's any reason, anything in your background that would make you uncomfortable, and that kind of thing. And then we always make them promise that they would do their best to be fair and impartial to both sides. And it's not that hard once you get them comfortable with the idea that they have a responsibility to be fair. And if they can't be fair, it's okay. There's nothing wrong with not being able to be fair in this particular case because we're all there.
One thing I'm just curious about is how do you keep yourself like motivated with each one? Because I find and I've talked to many attorneys about this, when you in LA, for example, you have like panels of 40 coming in and you've gotten a lot of cause or a lot of hardship. And so you're, one day you're doing the mini opening and you're asking a lot of questions, but then a whole new panel comes in and you have to do the same mini opening, but the other jurors are there. And I got to try to stay sharp with my questions, but I'm getting sick of hearing myself repeat the same shit every single time. Then the third day, it's like even harder. The other jurors are like, come on, we've heard this. Yeah,
but Dan, isn't it more that you're worried about the other jurors being bored and the time pressure and the judge getting annoyed? I mean, in this case,
all that.
You're not boring any jurors because it's a new, as Kathleen told us earlier this morning, the jurors aren't sitting around for days. They're only there for one day. And so you're not worried about, oh gosh, are the jurors going to hate me if I keep asking the same questions? Because you're only talking to one person, which is kind of nice.
It is exhausting. It's like speed dating, right? So you're sitting in a bar and you want to meet the person that you like, and you're going to ask the same questions to like 6 different people until you find someone that maybe you want to have a second date with. And you have to be on the whole time. And it's hard to be on and positive and friendly and, clever and
yeah, that's what I'm saying. I think that'd be tough.
Sure. It will wear you down. Yeah.
Yeah. It's exhausting.
But you can't like in, here in California and a lot of states, you can't just say, the new people come in, you go, anything that the other jurors have talked about, any of the questions that I asked that you would have a yes answer to. I mean, you can't do that, which is a great little shortcut. But I think it hurts. I think it is kind of lazy because a lot of jurors will go like, no, and so you gotta ask or you're not gonna learn.
With every single person who comes in, what I say is, before I ask you any questions, let's just remind everyone where we are here. It's a malpractice case. The general issues in the case, right? So before I ask you anything, is there any reason you can think of why you would be unhappy or uncomfortable or unwilling to serve on this case? And all answers are okay, And I always ask people how they felt when they got their jury summons, because most people are like, oh, shit, I got to go to jury duty. But a lot of people really want to be on a jury. And I worry about the ones that really want to be on the jury, because I'm afraid there's something, there's some agenda or vendetta or something that they want to prove. So they're the ones I would ask more questions of. The person, everyone has that reaction when they get juried. It's very normal. But the people are like, I was so excited. I wanted to, come here and do something. They're the ones I worry about.
Can we explore that a little more? Because oftentimes you hear attorneys who say the opposite. Like you want people who are happy to be there, but I see your point where you're going, but can you just elaborate on that a little more?
Yeah, sure. So the normal person, right? I mean, the majority of the population, I believe, when they get a summons for jury duty, they recognize a couple things. 1, it's inconvenient. 2, it might be stressful. 3, it's complicated. 4, it takes them out of their realm of what they their everyday, what they know. It's a different process. It's intimidating to go into a government building and have to answer questions. And so the whole process is designed to be a little bit intimidating and uncomfortable and inconvenient. Nobody wants to do that, right? Unless you either are super interested in the law, which is okay, you're a justice crusader, which is probably okay, or there's something about the process or trial lawyers or doctors or something that you want to have a say in. The say might be good, but it might be bad. And if you have an agenda, I got to figure out what it is. Like, why is it that you actually are happy to be here today, sir?
No, that's a really good point. And actually, with Harry and I just picked a jury, and a guy came in real excited, and he like busted out this law book. He's like, I have the tort law book, judge. I know how this works. Like, remember that? He had it all tabbed, and we're like, oh God, this guy.
Right?
Yeah.
You didn't want him, did you?
Oh no, he was.
Well, he had some terrible views. Yeah.
Well, he had some terrible views, but he's also very enthusiastic about those terrible views, and he's very enthusiastic about it, that he knew more than anyone in the courtroom.
Yeah. And then when the judge asked him, can you refrain from reading that book and, just rely on my instructions? He said, of course, because it's all up here.
Yeah.
You remember?
I think that's a really good point, though, about, it's people who are too eager. There's like, why is that? Harry, what do you think?
I agree with Kathleen. It depends. I do find that a lot of them, the reasons are good, but I think you have to explore what it is and give them more scrutiny, because, it tells you something. I mean, I'd love it if they're saying, I love to make a difference, and they understand. I love jurors who say this can actually make a difference and not just about getting money to some plaintiff.
I don't think they come in with that, Harry. I don't think they know. Like, I'm okay if that's their motivation after they meet me. But when they first come in, I'm not that. They would be the real minority of people who are coming in. Right. And
They are.
when they tell me they're anxious or worried or nervous or it's going to be too hard or they don't understand medicine, then I say, that's all okay, because it's going to be my job to make it easy for you. And if you don't understand the medicine, it's not your fault. It's mine, and so that they start to feel more like maybe this will be okay. And I tell you, I talk to all of my jurors after a case, win or lose. Sometimes it's the hardest conversation I ever have, but I always talk to them, and I've never had a juror tell me that they didn't enjoy the experience and didn't get something out of it, and so and I think that's very common across the country. And so you can sort of bring some of that into the jury selection and say, it's okay, everyone's nervous on the first day, everyone's nervous to be here, we're going to make this better for you.
The typical biases example, like Keith Mitnick, David Ball, all that stuff. Do you do that with every juror? Like you said, you kind of just introduce the concept of brutal honesty, biases, or what's your way of doing that?
I'm very soft pedaling on the biases, because I think most people think it's a bad thing, and I think they're reluctant to admit it. So I'm not even sure I use the phrase biases and prejudices, but I just really want to find out how they feel. So if you say to someone, and you give them the opportunity, because you make it sound terrible, right? I always say, how do you feel about a patient who sues a doctor because they're unhappy with the outcome? Even if the doctor did his best or did what he thought was the right thing to do, how do you feel about the patient that sues the doctor because they've had a terrible result? So it gives them an opportunity either to say, well, I'd want to hear the evidence, which is what they always say, most of the time. Or, God, I don't think patients should sue doctors. The doctors are just trying to, they're lifesavers, and then I know I have to explore that bias. And because I do only medical malpractice, it's easy for me to sort of stay in that lane. I think it's more complicated when you're talking about other kinds of torts and, other biases that people might have. But for me, that's a very standard question. And I frame it in a way that makes it sound like I'm expecting them to say, those people are terrible. Who would sue a doctor? Why would they do that?
Right. Are you even trying to really set up for cause? Because you don't have a court reporter, you don't have a judge. So are you like, there's no magic, like typically we're trying to, in California, a lot of states, are we starting behind? Do we have a strike against? Do we have an uphill battle? All those things, those keywords that we pluck directly from the case law. But I imagine, since you don't have a court reporter, how do cause challenges even work?
Yeah, it's a little complicated. We typically don't have a court reporter. So what happens is, if something is going on in the within the individual voir dire process, and one of us thinks that there is a reason for cause challenge, then we stop and we get the judge, and the judge will then come into the courtroom and go on the record. But here's what always happens, right? The potential juror will say to me, well, if the judge tells me that I have to follow a law that I completely disagree with, my conscience is not going to, that's going to be really hard for me. I'm not going to be able to do that. And I don't care what the plaintiff's injuries are. I can't award millions and millions of dollars because it's going to raise my insurance rates and blah, blah, blah. Right. So I say, this is for cause. I go get the judge, and the judge says, like, leans over the counter and says to the juror, if I told you what the law was, and the rule is that you must follow the law as I give it to you, you would be able to do that, wouldn't you, sir? You know, and the juror always says yes. And then I use a peremptory. We get 4 peremptories, and we have to seat 6 plus 2 alternates. So 4 peremptories is usually enough for me to weed out the really bad folks. But I'm not trying to get 6 great jurors. I'm trying to get 2 good jurors and 4 neutral people, usually.
And does it have to be unanimous in Connecticut, or is it 4 out of 6?
6 unanimous.
Okay.
Yeah, 6 unanimous.
And because you're using the strikes as you go along, do you find that your chances of getting a really good juror are kind of later in the process when the defense is running out of strikes a little bit? I would imagine if you get somebody good early, you're like, they're gone, you know, but
yeah, 100%.
If the defense has 1 strike left.
Right. That's 100% true. And so the game is always, you know, you don't want to let the really terrible person on. You don't want to use your but you don't want to use your peremptory too early because you've got to wait till the end. And inevitably, someone terrible for one side or the other is going to come on at the end.
Yeah.
And using that last strike is so hard. So it's always a game of, you know, who's next. And like I said, we don't know who's next. We don't know what's coming in, you know, into the room next. So it's very, very challenging.
So how many jurors do you question before you start using peremptories?
Well, if I see a really terrible one first, I'll use one early on.
No, you do peremptories. You have to make that decision after each juror has been voir dire.
Oh, after every single.
So
and only when you have enough jurors, right? Are you now the jury's? Now we have a jury because we've.
Right. So it could be that you saw 4 terrible jurors in a row, but not bad enough that you had a for cause. And I used all 4 peremptories, and now I've got to get 6 jurors with no peremptory challenges left.
God.
That could happen.
And you have no idea who's coming up next. You have.
No, we know a name, a town, and, you know, like sometimes how old they are or something.
So then do you guys employ a lot of like social media research, or do you do any of that?
Well, it's hard because we get the list literally as we sit down.
Yeah,
right?
So do we here. I mean, we do the same.
And then some people will be excused because they have vacations.
Yeah.
And so then we go from like today we went from 25 to 10. So, and we don't have Wi-Fi in the courthouse, so it's hard to do anything. So we can sort of take a photo of the list and send it back to people at the office, or we can have someone on their phone, maybe, you know, trying to do something. But it is very hard for us to do the social media search that some people can do, because I saw this first juror within 5 minutes of getting the list. And so there's no way anybody could have told me anything about her. Maybe while we were questioning her, someone could get some information.
Yeah, can't you drag out the questioning while the search is going? Just, you know, really just run out the clock.
Yeah.
No
really
Wi-Fi.
Make it as tough on you as they can. I know.
Yeah, no Wi-Fi. I mean, you guys really try to believe in the Constitution. You want to go like pretend like it's 1776, huh?
That's right. Yeah. That's right.
No
Yeah,
Wi-Fi.
wow.
That is crazy.
Yeah.
You know, one thing that Kathleen, that you brought up that I want to throw in some advice for you on when I know that a judge is going to try to just rehab these jurors and say, hey, you know, you're fair, right? You're going to follow the law. One thing that I would suggest that it works really well is when you get a juror who's saying, you know, hey, you know, you shouldn't be suing doctors and your insurance rates are going to go up and blah, 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 or whatever they're saying. I always like to end with, it sounds like you're a really fair person, but is what you're telling me that even if you try your best to be fair and try your best to follow the law, you're still just not going to happen. When you tell them that, I found a lot of times that when the judge tries to step in, they kind of say, I'll try my best, Your Honor, but I just don't think it's going to, I think trying my best is not going to be enough.
Yeah.
And so I always like to try to arm them to stand up to the judge, which isn't easy, but,
Right.
And I know some lawyers, go ahead.
Yeah, I was saying one thing I've tried with some mixed results is I'll say, I completely understand. I totally respect your opinion. I want to thank you for being so honest with me. But here's what's going to happen. A judge is going to come in here and he or she is going to question you about this. And it's not because you did anything wrong, but we're just trying to make sure everyone has a fair shot here. And so when it's really important to everyone that you tell the judge what you told us, because we're not on the record here, right? And so when the judge comes in, it's okay for you to say exactly what you told to me, no matter what the judge says to you. Nothing bad is going to happen to you. Because they're afraid. I mean, when the judge comes in, they don't know what's going to happen to them.
Yeah, we had Kurt Zahner earlier, and he was telling us, he always tells them there's no juror jail. I like that phrase, because they don't really think there is.
Yes.
I mean, they think they're going to get in trouble.
Yeah.
But yeah, I find that telling them, and I've used different analogies. Like, if you're asked to fly a plane, you try your best, but do you think you're going to be able to land it? No, no. And say, is it kind of the same thing in these cases? Are you telling me that even if you try your absolute best, you have such strong convictions that you're just not going to be able to follow the law, even if you're trying, right? Okay. And then I find that it works really well when a judge tries to step in and bully them.
I love the plane analogy because everyone gets it immediately. Like,
yeah.
I do not want to be landing the plane. Yeah.
I like that better than I never have liked the Vegas spouse analogy. Have you heard that one? That one I'm just like, especially when guys say it.
It's funnier.
It's terrible. But it's also
it's a
like
little offensive. Yeah.
It's just, I think it would piss off some people.
You haven't heard that one, Kathleen?
No.
I'll tell you the one. It's lawyers love it because they get a laugh. But they say, can you be fair? And they go, well, I'll try, because they've expressed some doubts. And you say, well, imagine if my wife was going on a business trip to Las Vegas and I said, are you going to promise to be faithful? And she said, I'll try, and then everyone laughs and it's, except for the people who are like, that's kind of a misogynist.
Or the people who have been cheated on or whatever. It's like, yeah.
Right.
Yeah, I mean.
All those people whose wives went to Vegas and cheated on them.
Yeah.
I don't see how that gets you anywhere other than the jurors laughing,
Yeah.
Yeah, I do like the plain one, though. I've used that one. One thing I wanted to ask, so you obviously spend the time asking questions. The defense does. Does your strategy start to change with the subsequent jurors? Like after you hear what the defense is starting to ask, do you kind of preempt some of those questions now because you've heard them? You get to go first. How do you handle that?
100%. Right. Because you sort of know plaintiff starts jury selection going first, but as soon as you hear what they're asking, you're like, oh, that's what they're worried about.
Yeah.
They're more worried about liability than they are about damages. Or my favorite thing to learn is that they're looking for dumb jurors, because then you have the better case. So as soon as I hear what they have to say, I can sort of, and by the way, sometimes I'm looking for dumb jurors, but as soon as you hear what they have to say, you can sort of change your strategy and try to it also helps with you knowing who to strike from the jury, who to get off the jury because you know exactly what they're looking for. So
yeah, because it probably, I imagine it probably alternates whether the plaintiff has the first chance to strike somebody or not. But there's no bluffing for you. So if you think a defendant is probably going to strike somebody, but you also hate that juror, you got to be pretty gutsy to bluff, right?
Yeah. Oh yeah. And the worst position to be in is when we have more than one defendant. So like today, I've got 2 defendants, and there will come a time when I am sandwiched between them because we rotate. And so like the first juror, I say first, I'll accept the juror or strike, and then defendant. But then the next time around, the defendant's going to go first. Yeah. So it's going to go defendant, then me. But
and
then
they can just bluff. Yeah.
Me. And so they can. The
first person will always say accept, probably, because they know.
Yeah.
I wanted to come back and ask you, I'm so super fascinated. What do you or defense counsel ask to find out if a juror is dumb? If they're looking for dumb, you said if they're, you can tell they're looking for dumb jurors. Is there anything particular that they're asking?
Who did you vote for?
No, but you can sort of tell. People who answer the question in, kind of an ignorant or mean way. I'm trying to think of an example. Or they're flip about the injury. So the case I have now is a guy who had a prostatectomy for prostate cancer, successful, cancer-free. He had some complications after, and he has incontinence of urine, and he has erectile dysfunction. And some jurors would think that was sort of, there was something funny or, something that they could say about that would be ignorant. And so those are the people that obviously we don't want on our jury. Education matters a lot in my cases because I have to make sure that they're understanding at least the basics of medicine. I'm trying to think of like an example of a really dumb juror.
On this kind of case, would you want to prefer male or female jurors?
So that's such a good question. All that what do you professionals call it? The bias for when the person is like the plaintiff.
Yeah.
So you think
similar.
But they're not because they would say, I would never let that happen to me.
Yeah.
There's some
similarly situated. Yeah. There's I know what you're saying. Yeah.
In my obstetric, I do a lot of obstetric work. And in my obstetric cases, my birth injury cases, I do not like women.
Yeah.
Now,
I agree.
Can't pick based on gender because it's, everyone, it's not allowed. However, given a preference, I do not like to put women on my obstetric juries because for 3 reasons. One is most women love their obstetricians. They just do. And 2 is women are very judgmental of other women. And that would include the mom in this case. I would never have allowed that to happen to my child. And then 3 is they're often overly judgmental of me. And so I don't like to put women on my obstetric juries. In this case that I have now, given the injuries this guy has, I think it would be very good to have men on the jury in general, just because they'll understand the nature of what he went through and the damages. So it depends. My $58 million verdict, that jury was all men.
Can I give you a fourth reason
Yes.
why women are tough in those cases? So I would say pretty much every man could not even fathom or tolerate what women go through in terms of medical care in those areas. And so you have an injury or something involving those areas. I think for most female jurors are like, yeah, I've had
Big deal.
these exams and they're, and you just suck it. Oh, okay. I mean, it's not comfortable, but you tolerate it and you get used to it. Men, it's like, oh, I can't even imagine if something.
Well,
so
the imagination is the most powerful thing we got.
Yes.
Right? It's just like,
Yeah.
it's like why you
Men are
don't
bigger-
show the photos.
men are much bigger babies about things going on in that area than women.
In my big verdict, also, out of 6 jurors, 5 of those men were under the age of 30. One kid was 18 years old.
Wow.
Yeah. And he came in on a Friday when we were in the middle of the trial in a tuxedo because he was going to a prom.
Oh my
that's-
And
God.
he came
dude.
in and he goes, he like looks at me. This is where we were well into the case. He looks at me and he goes like this. Like he knew.
Nice.
You know,
yeah.
and so,
The defense should have wrote the check at that point.
I know they didn't. They
They
didn't.
did it, yeah.
I had last year I was picking a jury in a med mal case that involved ED, and so it's too bad you don't have voir dire in front of the crowd, because I remember there was one juror that said something so basically said like, and this guy is like in his late 60s or early 70s. He's like, he's not gonna, and he was a widower. They heard that. They're like, he doesn't really need it to use it anymore. What's he gonna do? And you could just hear this gasp. Most of the jurors were like,
Was it like
And
a young kid said that? Like who was that?
no, it was like a middle-aged woman who said it.
Oh, middle-aged woman
She would
said
just
it. Okay.
yeah.
Okay. Yeah.
And but and that was the moment that my friend's trying the case, Keith Bruno, who was really, to that point, he's always kind of pessimistic about it. He was like, that's when he realized like, oh, they're actually going to value this guy's sexual function, even though he's a widower and he'd already had impotence issues and he's, in his late 60s, early 70s. And he was kind of like, I think most people are going to be that way. But it's sad that you can't see reactions from other jurors, because out here, when somebody says something controversial, the first thing I'm looking is who is nodding and who's rolling their eyes and who's upset by that comment. So,
Well, I do think it's a disadvantage for us. I think it's a disadvantage in a number of ways, including that, but also I don't get to really see how these folks are going to interact with each other. So I don't know who's going to be my alpha juror, who's going to go along, who's going to speak up, because until you see them together, and the dynamics of a jury changes as the trial goes on. You can watch how they change the way they dress, they change the way they walk into court every day. It really does evolve, but you don't get to see just in the jury selection process how they're going to interact with each other. And that's hard, because you got to get, as Mel Orchard's always talking about building his tribe, but you got to get a group that's going to function in some capacity together and cooperate.
That's what I was saying. It's like a Love is Blind. Like they all of a sudden just pop out and they're all together. Like I mean, it is tough to form that group.
Yeah.
Kathleen, can I ask you, have you ever had a juror say something kind of negative and everything and use it with another? I don't know if you're allowed to do that, but say, hey, we had a juror earlier today or yesterday that said this. How do you feel about that? I mean, even though they don't get to hear it,
Yeah.
I'd still love to.
Harry, I probably have, because it sounds like something I would do, like, especially when you're trying to give them permission to say something that might be negative.
Yes.
We've had people before you who said something. I can't think of exactly what I would, but it makes a lot of sense. And if I haven't done it, I'm going to do it. I'm going to use it next time.
Do it for sure. Because I know some lawyers like to use their, they'll say, hey, my dad or my mom or my brother hates these kind of lawsuits. And so it kind of makes jurors feel like, okay, Kathleen is not going to get mad at me if I say that, because her brother, her best friend, or whoever feels that way. But yeah, I think using other jurors, they hate to be the only one to say something. If you make them feel like you're not the only one, then,
right.
Oh, okay. In that case.
Well, in that first meeting you have with them, do you do like a mini opening, or is it like someone else read a statement of the case? Can you talk?
There's an agreed upon summary of the case. This is a medical malpractice case. The plaintiff is so-and-so. The defendant is so-and-so. This is the hospital. It involves a birth injury to a child. The plaintiff claims the doctor should have done a cesarean section. The defendants deny that, and the plaintiff claims damages. So it's very, very cursory.
I see.
So they don't really know much, but they know, I mean, people, as you know, have very strong reactions to medical malpractice cases. And the defense always thinks that the sympathy is going to be for my clients. And what we have learned, and you guys probably have seen this, is that there is an enormous amount of sympathy for the physician who's been sued. And so I always say to them, the judge is going to tell you you're not allowed to have any sympathy. And that goes for both sides. You might feel sorry for my client because they've suffered a terrible injury or loss. You might feel sorry for this doctor because I've sued him and I claimed he killed this man's wife. And so you might feel some sympathy for him. You have to put all of that aside. And then they say, yeah, I think I would feel terrible for the doctor. That's a terrible thing to accuse a doctor of, which then leads me to my burden of proof question, which is, people say the scales of justice, blah, 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 51%. But in a malpractice case, I am convinced that they will never give me a plaintiff's verdict if it's just 50 plus 1%, because it's too important. The allegations are too serious. The injuries are too serious. You're claiming this doctor did that to that kid. I think so, but I'm not convinced. And so you really have to work that into the jury selection because people have to think about it. It's hard.
So what is your burden of proof question?
So we talk about the burden of proof because they've seen a video, right? So I say, this is not a criminal case. The burden is not, as you've seen on like Law and Order, whatever TV show you watch, it's not beyond a reasonable doubt. It is a preponderance of the evidence. That means scales of justice. If I tip it just a tiny bit, plaintiff wins, right? But that is really hard for some people to understand. And so I want to make sure that you understand this. In this case, my client is saying that this doctor, because of what he did, this child has cerebral palsy and will never get out of that wheelchair. That is a very serious allegation. We can agree on that, right? And I intend to prove that. But my burden, I want you to understand this, my burden is just a preponderance of the evidence. 50% plus a scooch, 50% plus a hair. That's my burden. And the law says that if I reach that burden, you must find in my client's favor. But that's really hard. It's a really big deal because this is an important case, blah, blah, blah. And then I ask them if they think they could do it. And you can see people thinking like, and when I argue the case, I always say, if you think I'm right, I'm right. If you're sitting there and you're not sure, that's okay. But if you think it's probably true, it is true. The law says it. You must find it to be so, because that is the burden of proof is, I think, the hardest thing for us in these cases, because people don't get it. They want to be sure, and they don't have to be sure.
And it's something that's probably not talked about enough in jury selection, to be honest.
Sometimes,
and I'm kind of guilty of that too. Sometimes I'll put it way down my outline or what my topics I want to cover, and I just don't have time. I mean, we're a lot more constrained on time, I think, than you guys are. But still, I think it's something I shouldn't, to try to avoid skipping over if I can. It's just when you have like 30 minutes, you got to get to, the liabilities, money, and all that. But
yeah,
I actually like to frame when we do burden of proof. I actually like to frame it for the jurors in a way that makes it what I tell them it's easier, and which is a different approach. But I always like to tell them, in a criminal case, to find somebody guilty of a serious crime, you have to be 100% sure. And I would tell, nearly 100%. If you were sitting there thinking, I think this person, 80% chance this person killed some people, and I have to find him not guilty, that's tough to do. And I always tell them, in a case like this, it's a lot easier for you. You get to, if you think it's true, you get to, but then of course you have to say who feels like that's too easy or who feels like. I'm always worried about telling them that it's really hard.
I like that. I really do like that.
Yeah, I like that a lot too, because I think people just naturally take that weight off their shoulders when you tell them their job is going to be easier than the juror down the hall who's going to, in a criminal case. I do like that.
But the difference, Harry, is, and I got to think about how to frame, but the difference is that in a criminal case, there's a really bad guy on the other side, right? I mean, that's who's accused of doing something terrible. In my cases, it's this, doctor. Right. They're so nice. They're so good. They save somebody's life, So it's a little bit harder, but I think I do like that. I do like that switching.
I mean, I guess you could tell them, I don't know if you're allowed to tell them nobody's going to lose their license, because that's one worry that they have. Are they going to lose their license? Yeah. You do? Okay.
Yep.
Yeah. And the reason for that is in a criminal case, someone may go to jail the rest of their life or for most of their life. And in a case like this, no one's going to jail. Nobody, and if you can say it, no one's going to lose their license. It's just about compensation, and hopefully that helps. But I agree. I mean, for some people, I like to talk to them about what are you going to do if there's like a what, there's always going to be what ifs, because there's no camera, there's no video camera in the surgery room or whatever, but just because what if this person, I'm sure in a lot of cases causation is, what if this person just had this condition already, from birth or whatever. So
causation is always the hardest thing.
There's always so many what ifs, and they're so easy. A couple of times I've gotten jurors talking about like how easy it is to say what if, though. which is always fun. All right. So want to thank our sponsors again. The first one is Verdict Videos. Kelly Deutsch. If you don't know Kelly Deutsch and Verdict Videos, welcome to the plaintiff bar. I know that, for Dan and myself, we work a lot of the same cases. I know for my wife and I, we have focus grouped their videos in focus groups, and jurors have loved what they've seen of these things. I've seen the increase in value, and the settlement value of these cases is sometimes tens of millions of dollars more after the jurors watch their settlement doc videos or day in the life videos than before they watch the video. And day in the life videos, I don't know if you use them, Dan, but they're not just for trial. Settlement videos for mediation are an effective tool for trying to settle cases pre-lit too. I'm sure you use both of them.
Yeah, I mean, the best thing about working with someone like Kelly is that you're not handed off to some, other person, or you're just dealing with projects. Like you will get Kelly's cell phone. She knows how to talk to clients, and I think that's one of the hardest things when someone's to be invited into their home. She'll talk to the client. She'll sit down with the client. She knows how to tell a story, and she's just such a wonderful person, like truly empathetic, compassionate. She really understands what a client's going through, and that shows through in her production. And she's wonderful. We love her. She's just, she contributes to the community. I know through LATLC, the charity and all that. She's just a great person, very easy to work with, great pricing, and really will add a lot of value to your cases.
And I know what a lot of lawyers that I talk to love most about Kelly and Verdict Videos is they are always honest about whether they can help or not. I know there's cases where she has said, I don't think I can in this case, but I know that she's told me, our motto is video can hurt you as much as it can help you. And so I know she actually cares and is strategic about how she can help in these cases.
Which is very true. I think in general, like everyone's like, oh, I need to have the best animation. I need to have this, that, and the other thing, sometimes less is more. And again, it's great. It's important to work with vendors who are going to be straight up with you and who are going to be honest, like Kelly, and not just want your money from the case. Like she will be straight up, and those are the best vendors to work with. Another wonderful sponsor I'd like to thank is my dear friend, Melissa Baldwin from Baldwin Settlements. She is a structured settlement broker. She's fantastic. She's one of the first people I met when I became a plaintiff's lawyer, and has just given back, just great advice. She's another one of these people you can call and just, get some advice, and she'll really go out of the way to help you out. She supports CAOC, CALA, all the, AAJ. She's a huge sponsor of all these organizations. Her and her structure team work tirelessly with the attorneys and clients, and she really makes the hard fought result easy for the client. I mean, I had a very tough case from someone who was basically homeless, and she was able to make him understand he did not have any education to speak of, barely spoke English, but get him to understand how important it was to structure the money, because a lump sum and the many millions of dollars just would not have been good for him, given he had some issues with drugs and all that. She was able to speak to him at his level and get him a structure that really set him up for the rest of his life. And she was willing to work day and night, anytime, weekends, just to help get it done and get the best rates she can for the clients. So, and she also does not just structure. I used to think, I'd be like, look, when I was just starting out, my cases aren't big enough for you, Melissa. She's like, no. Like it's not just for the 7-8 figure settlements. It's really for all clients who just need some help to structure. And she can also structure fees, which is great if you want to put a little bit away for yourself and your family later on. So call Melissa Baldwin from Baldwin Settlements. Really great person, great friend. These two sponsors are just wonderful women that I really respect, and they run great businesses and good people. And lastly, we just again want to thank LawPods for making this possible. These podcasts, their whole library of attorney podcasts, truly help, all of us get better. And I highly recommend you just listen to them. I put them on the car. I'm listening to all these trial lawyers throughout the country with all the experiences they have. And it's just such a great avenue, because we can't make it to courtrooms all the time, but we're hearing from the best. So thank you for LawPods for providing that platform. Kathleen, I really do want to hear how you talk about money in this format, obviously, because it sounds like you have to deal with, obviously, the introduction of biases and all that we talked about. But how do you get to start talking about dollar figures? And are you allowed to bring up specific dollar amounts or say millions of dollars, many millions? What's your philosophy?
You mean in jury selection when
jury selection.
Oh, yeah. Okay, so no. In jury selection, we don't talk about money specifically. So And we are very lucky in Connecticut. We have no caps on damages.
I know. I heard
start,
that.
yeah, start there. Yay. So
Yeah.
we talk about it. What I do is I just break it down for them really simply to the economic and non-economic. Those are our two kinds of damages. And I tell them economic is just what you think it is. It's easy to understand. You can write things down with a pen and paper. It's lost wages and medical bills and rehabilitation costs and those kinds of things. And most people find that very easy to understand. The harder thing for people to understand is the non-economic damages. That's your pain and suffering and your psychological injuries and your mental suffering and changes in your quality of life. That's hard to evaluate. And people go, yeah, that would be hard. I don't know if I could do that. And then I ask them if there is in their mind any number above which they could never go. And somewhere along the way, I've probably planted some large number when I'm talking about the 300 million people that voted or something. And so they'll
Wait, sorry. What's that? What do you say about
I
the?
want to just get a number in their head. I want to get like a high number, like a little anchor in their head.
No,
So
I get that, but what's the 300 million people that voted? What's
I don't know.
like,
I just was thinking of
oh, I thought you had a whole burden of proof something. I don't know.
No, you put me on the spot. So anyway, so there's something I've mentioned maybe but I want them to be thinking about a high number. And if they say, I could never give you more than 1 million or 10 million or whatever it is, then I'll explore that with them a little bit. But I know that this is a problem juror for me. But mostly they say no. There's no floor, there's no ceiling, and they can understand that. And they talk about want to see the evidence, want to see the evidence, they want to see the evidence. When they express a concern about being able to evaluate or put money on someone's loss of enjoyment of life's activities, their change in quality of life, whatever it is. And they'll say, I don't know how I could do that. I say, well, you're the expert on that. We're going to bring in doctors who are experts on things like the standard of care and economists to talk to you about Mr. Smith's loss of earnings, but you're the expert on what it's like to have a life with pain or no pain, or know someone who has pain, or, to see someone with it. Like, you're the expert on that. And so it's going to be hard. Yes, we appreciate that, but this is what we're asking you to do. And so long as they're convinced that we're going to give them the information and they can talk to other jurors about it, and they're always okay. And it's very interesting to me that people talk about runaway juries, but it doesn't happen that often. Usually the verdicts are in the range that we predict they will be.
Yeah, so it's interesting because, and I've talked to Harry a lot about this, but when a juror gives me an answer on a cap, like they say, or when I ask that question, like, can you give more, or what's the, like, do you have some limit in your mind? Obviously, most jurors don't think about it at all before they've walked into that room and they've been asked that question. I mean, if I had a juror that said, 5 million or 10 million, or like they said something like that, I would not be that worried about that juror. I would be like, I do get concerned when they say no. I'm not sure. Like, how do you follow up on that? If they just say no, I don't think I have a cap. But what if they don't even know you're talking, $40 million or $50 million?
Yeah, I don't know. I mean, what I try to make sure they understand that there is a cap, and that the cap is the damages have to be, under our law, fair, just, and reasonable, right? And so you can imagine that in one case, fair, just, and reasonable is fairly minimal, and in another case, perhaps like this one, because they're going to know at this point what the nature of the injuries are, that fair, just, and reasonable is going to be a substantial number. I can't tell you now, but I'm going to ask you at the end of this case for a lot of money, and you're going to say it's justified, that kind of thing. And so I think I just want them to start thinking about high numbers. If someone says to me, yeah, I would have a cap, I would never give you more than $100 million, I'd be like, okay, yes, put this person on my jury.
If they say, so I assume there's just case law that says you cannot say even millions of dollars, right? You can't even.
I don't know if there's case law. I think the defense lawyer's head would explode if I said we're going to ask.
Do it then.
Yeah, exactly.
If I said I'm going to ask you for millions of dollars or multiples of millions of dollars in jury selection, you know what? I wouldn't be comfortable with it. I just wouldn't.
Really? Why?
Because they already think I'm a trial lawyer. It's all about the money for me. My client's probably greedy. This poor doctor, insurance rates, I don't want them to think that the reason I'm talking to them today, because I'm going to ask them for millions and millions of dollars. I wouldn't be comfortable with it.
Can you say it in an opening statement?
I wouldn't give a number, but I will tell them that I'm going to ask them for, we're allowed to do it in opening, I think. There's a great debate among my partners about whether or not you should. I think you have to earn it. And if I'm going to ask you for $75 million in my closing argument, I want you to think she has some credibility, and I'm not going to give her that much maybe, but I've watched her, she's credible, and we're going to give her some some piece of that. I don't want an opening statement again for them to think, ugh, trial lawyers.
Yeah, that's the big debate, honestly. And I go back and forth too. I used to say a specific amount, then I stopped, and I agree you have to earn it. And then sometimes you worry about the sticker shock at the end, and if like you only introduce the economic damages, say it's like $3 million, but you're going to ask for 50. So it's tough. It's a thing that I'm still struggling with to decide what is the right way to do it,
So, I mean, you have me thinking, I probably in jury selection could say there is no cap on damages. Our only cap in Connecticut is what's fair, just, and reasonable. I'm not going to ask you for $100 million in this case, but it is going to be substantial. Now, suddenly they've got $100 million in their head, right? It's going to be running around there for the next 2 weeks. I'm not going to ask you for $100 million, but it is going to be a substantial ask. How do you feel about that? I think I could probably get away with that because I just want them to have the big number somewhere in their head.
Randy McGinn, when she was on, she mentioned bringing up, what is it? A lot. If there was a lawsuit over a building,
if it was a bank or bank loan.
Bank. If a bank took $100 million loan and the contractor ran off with $100 million and we're suing for $100 million, I mean, how much would you? And then the jurors are going $100 million. So you get that number out there, and then she goes, would it be something that would it be different if we're talking about somebody's pain and suffering? And the bad jurors will start giving her reasons why a person's not worth that much, but you got the number out there. So I do like.
Also, I love that. And I love Randy McGinn so much. I would go anywhere in the world just to listen to her talk. And I'm going to write that down because she's just so, and also she gets away with a lot.
Well,
charming and, funny. And so she's amazing.
She does. There was also some rule. Do you remember this, Dan? She mentioned there was some rule in New Mexico. Oh yeah. You can talk about, you don't have to have punitive damages to talk about sending a message with a verdict.
Yeah, you can.
I'm like, oh my gosh, I'm moving to New Mexico.
Yeah. No, she did. Yeah, she's like, you can absolutely, say punitive damages talk without having that as
imagine that.
That's amazing.
Kathleen, I think you're right. I think saying either I'm not going to ask for $100 million, but also I think before I even would get there, because I think I would do Randy's question first, is it different for a human being? Get that response and then get some responses and be like, well, I'm not going to ask for that much, because I wouldn't say that right away. I would kind of do what Randy does. And I haven't done it yet. I'm going to try it though. My next one.
I'm going to try it too.
Well, see, you're in jury selection. You could do it in real time.
I think even when you don't want to talk about money, one way that you can talk about money without talking about money is, I always like to ask jurors, can a person's quality of life and the amount of compensation they get, could it be worth more than the lifetime of money they could ever earn? Because you have a lot of jurors who are like, no, it could never be. How could you ask for even $5 million? That guy never would have made $5 million. And you're like, and great jurors will say, a poor person's quality of life is worth just as much as Jeff Bezos or Elon Musk's quality of life. And sometimes I'll ask that, do you think that a poor person's quality of life could be worth as much as Jeff Bezos? And good jurors will say, yeah. Now they're thinking more than they could ever earn in their life. We're talking about many millions at this point.
But do you think the lifetime of paychecks one gets them thinking high enough numbers though? Do you think people will conceptualize?
I just say it could be worth more. It could be worth much more. Yeah. So at least they know. I mean, a person, especially a young person, is going to make at least a couple million if they're young enough, even if they're. So I think it at least tells you, are they willing to go over that? Once they get over that, cross over that bridge, I think. Either. I don't see a lot of jurors who go, I could do 7 million, but I couldn't do 15 million.
Yeah.
It's just.
Yeah. There's got to be a way to make sure the jurors understand that the economic damages, whatever they are the most minimal part of your claim.
It's a small fraction of
we again, one of the debates we have here is whether we even put in our economics.
Yep.
If I have a case with a $20 million life care plan, that's going in. But if I have a case where there's, $50,000 in medical bills, that's not going in. I'm not going to make.
That's not going in. And it honestly, even I'm starting to think $1 million life care plan, I feel like I'd be nuts to waive it. But if you're asking for 30 or more, and the first thing they have to do when they're deliberating is going through line items and cutting, and if you have a plan of that amount, you're going to have a lot of line items for 50,000, 2,000, 3,000.
Yeah.
And then they're thinking small right when they're starting to think about money. And so it's kind of I've had some of my best verdicts where I've just waived it all, even hundreds of thousands of dollars. So I'm definitely more of the camp. I think lately I've put in life care plans that are over $1 million, but I'm thinking if it's, if I'm asking for multiple 10 or 8 figures, I don't think it's worth it. It's a tough call. I don't know. There's really no right or wrong.
Right.
I mean, there's no It's a tough one.
Just bifurcate that part. Just have liability and non-economic damages first, and then
Yeah. Yeah, exactly. Like in your situation, so you start talking about money, they say no cap, and then is the defense typically saying, can you award zero? Are they doing that? Are they always saying
Oh yeah,
that?
if you're gonna hear about horrible injuries in this case, you're gonna meet this cute little kid and hear about what this family has been through, and the judge is gonna tell you to put sympathy aside. And so, if at the end of the day you find that the plaintiff hasn't proved their case, are you willing to send this family away with nothing? And I've never ever had a juror say, I couldn't do that. They always say, yeah, I could do it. And sometimes it's the speed that they answer the question with that is really
Yes.
disturbing to me. Like, you should at least think.
Yeah.
Isn't there some, aren't you going to hesitate? Like, don't you want to do something for this family? But they haven't met the family yet. They haven't seen the kid yet. They don't know anything yet. And so it's easy to, in this sterile environment, to say, yeah, I could do that. That's what I'm supposed to do.
So is the client ever present in your jury selections?
They can be, but I don't encourage that because I don't want the client telling me who they like and who they don't like and why they like them. And they don't know. They don't know.
What about for the client? Because what we do a lot here is we'll have the client just like when all the 50 people are there, they'll be sitting kind of right behind me, and then I'll have them excused. Like as soon as I start asking, I'll just like have them walk out.
Yeah.
So when would be the first time the juror would see your client or the
Opening
client's family?
statements. Yeah.
You have them there during that.
Yeah, because just remember, Dan, like if I'm picking a jury for 14 days,
Yeah.
I'm not going to bring my client into court every
No.
day for 14 days for really nothing. So the first time they meet my client is typically opening statement. And sometimes I don't have the client in for opening statement. That would be unusual, but sometimes I don't. I am wondering if there is a question. Do you have like a magic question that you ask or that you tell lawyers that you're working with to ask every single time?
I don't, but I'll tell you one that I really like in med mal cases, because my biggest worry in med mal cases are, I found the jurors who put doctors on such a pedestal that they can't second guess them. And so one thing I like to always ask them is, you're gonna have to decide what the standard of care is, and none of you are doctors. None of you, and in your case it's one-on-one. You haven't had any, as far as I know, you've never had medical training, right? And you're gonna have to hear medical experts on both sides disagree about what the standard of care is. And so my question is, do you feel like trust your common sense and your judgment enough to overrule what a medical expert is telling you? The reason I love that is I love jurors who think that they are smarter than doctors. That's why don't ever strike me. I think I'm smarter than every doctor, and I'm like, I can tell you if a doctor did screwed up or not. But those jurors who hesitate and go, I just would trust a doctor. How could I second guess a doctor? So I love asking those in voir dire on med mal cases.
That's good.
Yeah.
Well, especially the key word there is overrule.
Yeah.
I really like that.
You're going to have to overrule one of them. Yeah.
Overrule.
It's true.
Well, it's also good because it focuses on one of their anxieties, which is, how am I supposed to decide this? Like, you're going to have an expert. You're going to have an expert. Who am I to say? So it goes right at that anxiety and kind of gives them the opportunity to express it. So.
Yeah. And you tell them the system trusts your judgment. Our system doesn't want 12 doctors on this jury. We want people with common sense and their own judgment. Do you trust your judgment that much to say, sorry, I don't think this, I disagree with this doctor, or what a doctor did? And you just see some of them, a lot of jurors obviously say, oh, I don't know if I could do that. And, do you honestly, and in brutal honesty, do you kind of feel like if a doctor made a decision, they have so much experience and training, they must have been a good reason why. And if they go, yeah, you go, that person's just never going to feel confident enough. Yeah. But I want those jerks who very quickly say, absolutely, And so you were saying you like smart. I love smart jurors in med mal cases, but more importantly, smart jurors who feel that confidence, almost borderline arrogance, where they could go, I could do that for sure.
Yeah.
You said there are some cases where you don't want the smartest jurors. You do want some kind of dumb jurors. Like, what kind of situation would you not want a smart juror?
So every case has its warts, right? Some cases have more warts than others. And sometimes I need a juror that is not so perceptive or judgmental of the warts. Sometimes my clients are not terribly appealing. Sometimes the medicine is, not exactly on my side. Sometimes I want them to make a leap because technically causation is really, really hard. And if they can just say, well, this is how the injury happened and this is what the guy did and it seems like they're connected, and so sometimes I don't want the jurors who are so analytical, so precise, because I need them to make a leap with me.
Yeah, there's definitely cases where those analytical engineers who are going to just, examine every little exactly causation, and they need a higher burden of proof usually. So,
Yeah.
I
I have another question for you though. Is there have you, in all that you've done, have you ever come across either a profession or an age range or a type of person that you say, never again? I'm never putting that kind of person on my jury ever again.
no, because I found that there are always so many exceptions to the rule. I try never to judge. I can name you the worst professions that most plaintiff lawyers would just never keep. And they tell me I would never keep an engineer, I would never keep a doctor, I would never keep this or that. And I've kept them all if they're good. So I always believe they're human beings first and they're their occupation second. But there's certainly some that I go, okay, I need to really scrutinize this person. I mean, a doctor in any case, not even a med mal case, I'm always going to scrutinize a lot. But I found that every type of demographic and occupation, there are exceptions. And if you find that good one, gosh, the defense is never going to strike that person. And if they're great, no matter what they say. I mean, if you have, probably, Kathleen, if you get somebody who's like head of risk management at a hospital, but if they're really so good, their answers are so great that you're going, actually, gosh, this person would be amazing, the defense is just never going to strike that person,
right,
no matter what they
I'll
say.
put a nurse on my jury any day.
Yes.
I also think, Harry, and this is what we talked about recently with, I think, Sean Claggett, was that not every bad juror is bad for every case.
Right.
And you could have a juror that's bad for your facts, but they could be great on a different set of facts, different type of hospital you're suing, different type of doctor, different type of injury. So I agree with Harry. I mean, I think it's really, there's no cookie cutter way or cookie cutter person or cookie cutter juror.
I'll tell you though, in med mal cases, the one thing that always surprises lawyers and is really counterintuitive is the worse care that they've had with hospitals, the worse they usually are for you, because they're just not, they're like, yeah, this is how, they have really low expectations. They're like, so what that they, took 20 minutes to give her a C-section. Like, I've been in an ER with a bullet wound and sat there for 2 hours.
Yep.
And so defense usually is worried about them. They're like, oh, they have an axe to grind with hospitals. But I found that the best jurors are the ones who have super high expectations. Like, if you've been seen within a minute by every doctor and every time they immediately give you an MRI instead of made you wait, that's the kind of juror who's going to be like, I can't believe that they made this person wait for 20 minutes. And so I hate people who have just become cynical and jaded about bad care. And they're like, that's just how it is.
Right. Also, those people are going to say, not only did I sit in the ER for 7 hours with a bullet wound, but I didn't sue.
Yeah, exactly.
Why?
But even if they don't say I didn't sue.
Yeah. No, but in their head, that's what they're thinking,
Even when they think that they're kind of good for you sometimes, I just kind of go, they're just going to hear this case and be like, oh, big deal.
I tell you, the one of the biggest mistakes I have made, and I tend to make, is I get with a juror and I'm talking to them and I like them. I think they're interesting and I really want to have this conversation with them. I'm like, they'd be great. And I'm thinking, no, they'd be terrible. But I like them, and I want them to like me. And so I think that they'll be good. They are terrible. And it takes me a minute to get past I really like this person to they would just be a terrible juror for this case.
That's one thing Harry and I talk about a lot, probably not even on the podcast, just in general. It's like, some of us think that we can just, we form that bond. We're like, I like this guy or whoever I could have a beer with. And like, he likes me, we're into the same stuff. And, we're very similar. And then they end up being, your worst juror because we think we could just charm him the whole time. But
you can't.
And they like you afterwards.
Yeah. No,
they go, you were way better than another lawyer.
Yeah.
But exactly. Yeah. It's just, it's interesting. They actually do listen to the evidence, which is good.
And you know what they listen to? The judge's instructions.
Yep. Exactly.
They're not helpful to us. They never are.
All right. Well, with that, this has been great, Kathleen. Thank you so much. Good luck with your jury and everything you're doing, your leadership in the plaintiff's bar. It's really inspiring. I mean, I loved reading your bio. Really good stuff. So thank you so much. Really great advice. I loved it. I learned a lot. I wrote a bunch of notes down. So thank you to our sponsors. Thank you to Law Pods. We appreciate it as always. Harry, I'll see you soon, buddy.
Absolutely. Take care. Thanks so much,
I
Kathleen.
had a great time, guys. Thanks, Harry. Thanks, Dan.
Yeah, you're
Yeah,
terrific. I
thank
hope
you.
you do not have 2 more weeks of jury selection. I hope you get to open soon.
I hope so too.
If you're enjoying the podcast, the best compliment you can give us is sharing it with a colleague who would find it valuable. For all the best clips from the podcast, follow us on social media. You can find those links in the show notes. Have a jury selection story to share? Email us at podcast@pickingjustice.com, and we may address it in a future episode. Until next time, remember, you're not just picking a jury, you're picking justice. Produced and powered by Law Pods.